Sometimes parents cannot take care of their minor children and another adult steps in to care for them. When this happens, an adult can ask the court to be appointed the child's guardian through a guardianship case. In a guardianship, the court orders someone other than the child's parent to have custody of the child or manage the child's property, called estate, or both. Who can be a guardian? A guardian can be a relative of the child, like a grandparent, or someone who's not a relative, like a friend of the family. There can also be more than one guardian, like both grandparents. Guardianships can be in probate court or in juvenile court. This video is about probate guardianships. If Child Protective Services, or CPS, is involved in your case, you probably have to go to the juvenile court to find out what you can do. This video does not talk about juvenile court guardianships. Keep in mind that a guardianship is different from an adoption. Check out your court's self-help website to learn about the differences. Is a guardianship always necessary when the parents are not around? A guardianship is not always needed. There are more informal ways for a parent to give another adult temporary right to care for their children. For example, if you're caring for a child that's not yours, you may be able to use a caregiver's affidavit. This paper usually lets you enroll the child in school and get the child medical care. There are differences if you're a relative or not, but it may be a good option in your situation. Find out about the different alternatives to guardianship before you start the guardianship process to make sure you choose the best option for your situation. What can I do as a guardian? It depends on what type of guardianship the court orders. There are two main types of guardianship. A guardianship to take care of the child is called a guardianship of the person. A guardianship to take care of the child's property is called a guardianship of the estate. Let's talk about a guardianship of the person first, since they're the most common. In a guardianship of the person, the guardian may have the same responsibilities to care for the child as a parent would. The guardian may be fully responsible for the child's care, including the child's food, clothing and housing, safety and protection, physical and emotional growth, medical and dental care, education, and any special needs. The guardian may also be legally responsible, as any parent would, for any intentional damage the child causes. In deciding to appoint a guardian for the child, the court will look at what's in the best interest of the child. The court wants to make sure the child is raised in a safe, stable, and loving environment. A guardianship of the estate is set up to manage a child's income, money, or other property until the child turns 18. A child may need a guardian of the estate if he or she inherits money or assets. A guardianship of the estate is not needed when a child does not own anything of value or only gets Social Security benefits or some type of welfare benefits. In most cases, the court appoints the surviving parent to be the guardian of the child's estate. In some cases, the same person can be the guardian of the person and of the estate. In other cases, the court will appoint two different people. Talk to a lawyer if you're not sure if the child needs a guardianship of the estate. How to become a guardian. Once you decide to become a guardian, there are several steps you have to take to ask the court to appoint you as guardian. We'll give you the main ones, but keep in mind, we're just giving you a general idea of the process. First, you'll have to file a petition for guardianship in court. Second, when you file your petition, the clerk will schedule a court date. Before this court date, you'll have to let all of the child's close relatives know about the case and court date. If the child is 12 or older, you'll also have to let the child know. You have to do this in the proper legal way called giving notice. Third, if you're a relative of the child, the court investigator will be appointed to the case. If you're not a relative, the county's Children and Family Services or other designated county agency will do the investigation. In both situations, the investigator will do several things before the hearing. The investigator will visit the home where the child will live. They will meet with the child and you as the proposed guardian. They will review important records related to the child, like school and medical records. They will talk to other people who are involved in the case and can help the investigator understand everything that's going on, and they will do a background check on you and any other adults living in the house with the child to make sure it's a safe environment. After the investigation, the investigator will write a recommendation for the judge. Fourth, At your court date, the judge will make sure all the legal steps were followed, read the investigator's recommendation, and make a decision. If the child's parents agree to the guardianship, a judge may order a guardianship if it's necessary or appropriate. If one or both of the parents objects to the guardianship, a judge will order a guardianship only if staying with the parents or one of the parents will be detrimental to the child and the guardianship is in the best interest of the child. If the judge orders the guardianship, the judge will appoint you as the guardian. This means that you can take care of the child in the ways the court orders. What happens next? Every year, the court may ask you to fill out a status report to let the court investigator know how things are going. If there seem to be no problems, everything will likely stay the same, and you'll need to turn in another status report the next year, and so on. Sometimes the court will ask you for more status reports or will order you to go to court to talk to the judge so that they can make sure that the child is doing well in your care. Still have questions? To get more information about guardianships, visit your Superior Court's website, especially the section on self-help. Your court's self-help center may also be able to help in person, but check first that they help with guardianship cases.